Hello everyone, welcome in. I was gonna wait on doing a video about the jury procedure in New Mexico until we got closer to trial, but nonetheless, with Gary Mitchell's latest motion asking for supplemental jury questionnaires and essentially throwing all the shade in the world at anyone who cares or talks about this case online, I figured we can prepare ourselves and understand the jury procedure. So, they will be finding 12 jurors to actually sit on the jury and 6 alternates. I cannot tell you exactly how many people will be called for jury service in this situation. Lori Vallow Daybell's trial, they called 1,800 people, and they narrowed it down to the exact same number of jurors. So, depending on how many jurors get submitted, we will see. Gary Mitchell is thinking it's going to take anywhere from 2 weeks or something like that, I think he said. So voir dire and jury selection could take an extremely long time. They will, once you narrow down anyone who is just disqualified for, let's say, medical reasons, they have it, depending on how lenient the court is, if they have a trip that's been planned for a long time, non-refundable, things like that. Some people will just get disqualified, a huge number right off the bat. They don't want to be there. That's not usually a good enough excuse, but oftentimes an extremely disinterested person will not be wanted. So there is a lot of disqualifiers that will come in before the good cause strikes for implied or actual bias as well, which implied bias would be someone near you, or depending on your life situations, we can infer you may be biased in this situation, and then actual bias is you are clearly and actually going to be biased in this situation. There's an unlimited number of good cause strikes. Again, that's to ensure an unbiased jury. It seems in New Mexico that the state and the defense ask for the strikes, that the judge doesn't rule over the strikes for good cause. And so that's different than I've seen a lot of cases in a lot of states and cases that I've been on where the judge will do a lot of the good cause work and question people for disqualification and mainly. But in New Mexico, it also seems that any strikes are made outside the presence of the jury pool. So they are not allowed to know if the state or the defense struck certain witnesses, which is also interesting because in a lot of states, these strikes are made out in the open. And so in New Mexico, it's very secretive. The strikes are made only in front of the judge. So I'm assuming it looks a lot like they go through, they question every single juror. They dig deep into their history after they've not been able to be disqualified for any kind of regular reason. And then when they find the people with biases, they go behind closed doors and strike them with the judge. Same with peremptory strikes, which a peremptory strike is any strike, think of it as a strategic strike. It's any strike that you would want to use to take a juror out who is not going to be benefiting to your cause or to your client, right? And you don't have to have any real reason for it. The only challenge to peremptory strikes typically is if it's clear you are only using a peremptory strike to strike them for a protected characteristic like race or gender. In this case, that might come up because they have said that they do not want women on the jury, and so we will see if there's any kind of legal trickery going on with them trying to peremptory strike women for no reason other than that they're women, and that may not hold up, but that's really the only way you can strike down a peremptory strike. And so you can challenge it, but typically they go through unless you can prove that there is discrimination happening, and oftentimes attorneys will come up with a BS excuse because for some reason you do not want this person on the jury, and there's no bias, there's no anything else, but they fit a perfect category of the person you don't want on the jury. You may need to find some BS reason that doesn't look like it's because of their race or their gender, because sometimes there are racially motivated or gender motivated causes of action that are happening, like sexual assault or hate crimes and stuff where race or gender could be playing a huge factor in your jury, But again, you're not allowed to make those decisions specifically off of those things. So the defense will get 12 peremptory strikes and the state will get 8. Again, that's just to make sure we have a fair trial here, because, the defense is who's on trial. They should get a little bit more strikes than the state to help make the jury better for them. Right now, it kept coming up really small when I tried to bring up the actual picture of the jury questionnaire. So here's all the information that's on the current New Mexico jury questionnaire. Name, age, ethnic background, the neighborhood you live in, you, your partner, and your children's occupation, your education level, if you belong to any kind of religious, social, civil, fraternal organizations, what is your political affiliation, you or anyone near you work for an insurance company, which, kind of makes sense because a lot of times insurance companies are being sued and whatever. So you or your family ever been a defendant in a criminal case, ever been employed by the court, law enforcement, jail, prison, attorney's office, and do you have any disabilities that the court should know about? So they are asking for a supplemental questionnaire. Something interesting in New Mexico law, the party requesting supplemental questionnaires have to foot the bill for them for being produced and mailed. And so depending on how many jurors are, being called for this case, it could be anywhere up to 1,800, even more, but probably not. I'm assuming somewhere around or under the Lori Vallow day bail numbers. So it might be a good couple $1,000s for them to have to put out this supplemental questionnaire. I'm assuming it's going to be mainly focused on your social media history because they've already mentioned that. They're trying to preclude anyone with social media use, but that's never going to happen. If you just watch cat videos all day, that's no reason to strike you down. And so they're probably also going to try and strike down healthcare workers because, again, that's really their main defense, is they're throwing the healthcare workers under the bus, right? And so saying it's all their fault. And so they probably don't want a lot of healthcare workers on there. Oh, and one more thing about it, why they might want to go a little deeper in is because, let's say, it's only asks your current occupations and all that. It doesn't ask, you have a history of doing it. I know it asks for your education level, but you could have studied nursing or biology or anything like that and never used it. Or you could have studied something else and ended up in a hospital setting for some reason, and they're going to want to dig deep into that because let's say you were a nurse for 20 years, but that doesn't show on your jury questionnaire, and then you became or 30 or 40 years, let's say you were a lifelong nurse, and then you became a nanny for the last 10 years of your life, and that was your most recent job. They may overlook that and not find out that you were a nurse for a long time, and they probably don't want you there. So jury procedure for the conviction of lesser included offenses. Now, what I did not find and could not find was when this needs to be included in the jury questionnaire, if it is before trial, when they're explaining everything to the jury, or if they're able to add it before the jury deliberates. I'm going to assume earlier rather than later, but essentially, a conviction of a lesser included offense, the legal term, the official definition is kind of confusing, and so I'll try and explain it the best I can because it's not that confusing, but how they word it is very confusing. Essentially, either side can ask, usually it's the state, would ask for a conviction of lesser included offense in the off chance that maybe the highest offense that they're asking, like in Alexee's case, murder 1, maybe they're worried about the threshold being met, or they want to ensure that this person is found guilty for some reason because the act was so heinous, okay? So could be evidence-based, it could be just cover your butt-based. But essentially, any crime that can be a crime of lesser offense is any crime that can be included in the larger crime that's being charged. Okay, so if they're charging you with murder, they can also ask that you would find attempted murder, assault with a deadly weapon, attempted assault with a deadly weapon, and it goes on and on and on. So far as, in case they didn't meet the burden to prove that you murdered them, but you assaulted them with a deadly weapon and attempted to murder them, do you see what I'm saying? Then you could still get a charge. Now, I'm sure Gary Mitchell is going to fight this like hell if they try to put this in. I don't think it necessarily has to do with having a weak case. It could, But in, this case is a battle of the experts, so it could be because they see who Gary Mitchell's expert is, and they're like, this guy might really put some doubt in the jury's head. Let's add some lesser included offenses on this just in case, right? I'm having hope that his expert, he is not going to do a good job with the jury. Hopefully he's aggressive and seems like a liar and shady. That's what I'm hoping, because people do not respond well to feeling like the wool's being pulled over their eyes. That is not good for a jury. So I'm really hoping that that's how their expert behaves and just completely turns off the jury. But nonetheless, we'll have to see when we get there. And if they do have a strong expert who is able to eloquently and charm the jury in a sense, maybe the lesser included offenses could also be beneficial to the people hoping for some kind of charges to stick, right? So those are all the rules. My thoughts: the defense in their motion will have made it clear that they prefer that they've already said this, that they made it clear that they prefer well-educated, scientific male jurors. They say that women specifically have vitriol towards Alexee. I do not think that will help. You can get anyone you want, from the highest educated to the lowest educated, and I think everyone's going to be able to see the situation for what it is. I think it's also really classist in a way that they're talking about these people are uneducated and they can't see the science. First off, Gary Mitchell in the motion thanks for gaslighting everyone, and number two, don't put anything past blue collar worker people who don't have a piece of paper to their name with this education on it. Don't put nothing past them, because they are some of the best salt of the earth people who will find the truth in the matter, okay? And they care. So Gary Mitchell's being a real jerk when he's trying to gaslight everyone and say that we're too stupid to understand what really happened. And that's not going to play over well with people who already think this dude in a suit who is a lawyer for 30 years thinks he's above them. So I can see why they're trying to ask for an educated, scientific male jury. But again, it doesn't matter who you have. The evidence is the evidence. The state, unless they feel that they've made their case extremely solid and that there's really no wavering in it, they'll hopefully ask for a lesser included crimes to be on the jury instructions, and it will hopefully be granted despite Gary Mitchell fighting like hell to keep it out. That will ensure that the guilty verdict of a lesser but still felony charge will be applied to Alexee, because mainly it's the autopsy that I am thinking that that's what the whole charge kind of hinders on. If they can make the jury believe that the autopsy didn't prove that the baby was alive, you don't have murder, right? Well, it's all also about the jury's gut. You can try and put as much proof up there as you want, but if they think that Alexee thought the baby was alive, they can still charge her with murder. And essentially, I think they'll try and undermine the autopsy, but I don't really think it'll matter because, again, common sense. Defense will likely try to stack the jury. They might even try and use good cause and bad faith, which, I forgot to mention that on the strikes page. Sometimes attorneys who are shady will use good cause to attempt to strike down someone they should use a peremptory strike for. It's bad faith, but it happens. You can try and weasel it in. I've seen it 1,000 times where you're like, we should strike them for good cause, and it's no. In this case, it would be very blatant, but this is a way to explain it. They're upset that it's a woman who has a kid, is pro-choice, but they get that feeling and they know that she's going to find Alexee guilty. They try and be like, can we strike on good cause? And in reality, they should use a peremptory strike. And so sometimes that'll be picked up on by a judge or the other side, and they can try and stop it. But it is a common practice, a shady move, to try and weasel in good cause strikes when you should use peremptory ones. So I do think that they'll try and do that because, again, he's a weasel and he's slimy. And so that's what Gary Mitchell seems to do. I believe in, this is my final thought, a positive thought, I believe in the intelligence of all humans, and I think that the common sense will prevail on the jury despite them trying to cherry pick education levels and everything like that. You can get the most educated Harvard, Yale, Princeton educated jury that you want. I think their gut is going to tell them that Alexee wanted to ensure that baby never breathed again, and that's murder. So this has just been me going through some of the jury information. We will hear 12 jurors be sat and 6 alternates be chosen. Then we will have trial begin. Hopefully they don't try and pull any shadiness with their peremptory and good cause strikes. But again, it's Gary Mitchell, so we will see what happens. Thank you so much if you've made it this far in the video. I know it's a long one, but there is a lot that goes into jury selection and voir dire. So thank you for listening. I will see you in the next video. Okay, bye.